Copyright law is one of the foundations of the music business, but where can copyright law be found? U.S. copyright law is divided between three sources: Title 17 of the Code of Laws of the United States of America, Title 37 of the Code of Federal Regulations, and case law. After the U.S. federal government passes a law, it is then published in three places. First, the U.S. Government Publishing Office publishes the new law as a slip law. Congressional sessions typically last a year. At the end of each session, the laws that were passed are published in the Statutes at Large, which is a chronological collection of every law passed by the federal government. Searching through the Statutes at Large may be cumbersome because a single topic might have had multiple laws passed about it decades apart. Because of this, laws are also published in the Code of Laws of the United States of America. This is often abbreviated as USC for United States Code. The USC is divided into 54 titles. Title 53 is held in reserve. The other titles provide a summarization of all of the laws that have been passed that relate to a particular topic. Title 17 covers copyright. So when the federal government passes a law regarding copyright, such as the Copyright Act of 1909, the Copyright Act of 1976, the Digital Millennium Copyright Act of 1998, or the Music Modernization Act of 2018, then Title 17 of the USC is updated to reflect any changes that the new law makes to the existing copyright law. For the most part, Title 17 is the primary source for U.S. copyright law. A copy of it can be downloaded from copyright.gov. The Code of Federal Regulations contains regulations set by executive branch departments and agencies. It is divided into 50 titles. Title 35 is held in reserve. The other titles cover different topics. Title 37 covers patents, trademarks, and copyrights. The regulations for copyrights are typically determined by the U.S. Copyright Office and the Copyright Royalty Board. These regulations are essentially a bridge between the law as passed and the practical implementation of that law. For example, Title 17 of the USC calls for the creation of a blanket compulsory mechanical license that interactive streaming platforms may use. Title 37 of the CFR lists the formula that is used to calculate the mechanical royalties that must be paid by interactive streaming platforms that use the blanket compulsory mechanical license. An online version of Title 37 can be read at ecfr.gov, and a copy of Title 37 can be downloaded from govinfo.gov. The online version is updated more frequently than the download version. Many countries have either a common law legal system or a civil law legal system. Under common law, courts are more bound by legal precedent, the rulings of prior courts in similar cases, more than they are bound by their own interpretation of the law as passed. This leads to a more consistent application of the law because similar cases typically have similar results. However, court rulings may supersede the law as passed, which could lead to the application of the law straying from legislative intent. Under civil law, courts are more bound to the law as passed more than legal precedent. This helps the application of the law retain legislative intent. However, since each court is left to its own interpretation of the law and is not bound by legal precedent, the application of the law may be more inconsistent. So a big difference between a common law legal system and a civil law legal system is whether they prioritize consistent application of the law over the preservation of legislative intent. For the most part, the U.S. has a common law legal system which it inherited from England. Therefore, some aspects of U.S. copyright law are not written in Title 17 or Title 37, but are instead written in court rulings of legal cases. For example, neither Title 17 nor Title 37 explicitly exclude chord progressions and drum rhythms from being protected by a musical work's copyright. However, various courts, including the court in Intersong USA v. CBS Inc. and the court in Tough America Inc. v. Diamond, have determined that those elements are typically not original enough to be protected by a musical work's copyright. So that is essentially where U.S. copyright law stands on that matter. I should also note that while chord progressions and drum rhythms are not typically protected by a musical work's copyright, a new sound recording of a performance of either of them would typically be protected by a sound recording copyright, assuming that sound recording wasn't completely generated by AI. I wrote a book, Contract Law and Copyright Law for Musicians, that further explains how Title 17, Title 37, and various case law affect the music business.